Hello, everyone. Very warm welcome to the EDF India webinar on FCRA cancellations and pending renewals. In the recent years, we have seen that the FCRA Act has specifically been amended in 2020, and there are specific reasons that were cited by the government as to why they chose to amend the Act. And this also comes in the light of the fact that, between 2010 to 2019, the annual contributions in terms of foreign funds within India had almost doubled, which also at the same time indicated that many organizations, especially the non-governmental organizations, were falling severely short in utilizing these funds for the specific purposes for which was allotted. There were many organizations which also were unable to basically meet even the basic requirements of what it means to actually have an organization up and running in terms of filing the returns on time. Many organizations fell short, and it basically resulted in many organizations losing their FCRA registrations. We should also remember that in the background of this fact, the government, in the name of ensuring that there is a strict compliance mechanism, in the name of transparency and accountability, they actually enacted the amendments. While this is a scenario on the one hand, we've also seen on the other hand, especially during June 2020, when the entire migrant crisis was really soaring in India, even the Supreme Court of India took note of the fact that many of the non-governmental organizations and many individuals have really come forward and worked with the migrant laborers, whether it is giving them food or arranging for the transportation, or for that matter, ensuring that they were able to reach their homes quite safely, and was able to kind of look at the immense contribution that the foreign organizations, the non-governmental organizations were able to make. But what we have also seen as a reality, that is after the coming of the Foreign Contribution Regulation Amendment Act, is that many of the organizations, especially the non-governmental organizations, were unable to open the SBI accounts on time. Many of them failed to file their annual returns under Form FC4 on time. Many of them even missed the deadline to renew the FCRA registrations. And in the beginning of the year 2022, we have seen that nearly 6,000 organizations have, their FCRA registrations lapsed. And even the Ministry of Home Affairs, the data clearly shows that the number of organizations within India have drastically come down to 16,829. So all of this gives us an overview of where we stand on this issue. And now moving forward, this is a webinar in which we will have, four important speakers who will be talking to us on three important issues. So the first issue is relating to pending FCRA renewals and cancellations, right of the NGO. And this is a part which will be covered by expert speakers, namely Mr. Raja B Singh and Ms. Manju George. And the second part is with respect to the legal remedies available in such cases. And this portion will be covered by Advocate Abhishek Jebaraj. And the third part, which is essentially dealing with the way forward, we have Tehmina Arora, who is the Director of EDF India, who will be with us and sharing very important insights on all of these issues. There are some housekeeping announcements to be made just for the benefit of everybody who was participating in this webinar. Firstly, you might have noticed that in the bottom of the screen, you will find two chat signs, one which says Q&A. There is a very, very strict and important announcement, that is, if you have any specific question to any of the specific speakers, you have to importantly type down these questions in that box which has Q&A, which stands for question and answer. If any questions are raised in the chat, they will not be looked into and the speakers will not be answering those questions. So it is a kind and an important announcement to all the participants to kindly cooperate with us and ensure that you all please enter your questions into the chat box which has Q&A, that is question and answer, specifically written. Secondly, if there are any questions that are written in the chat box, it will not be addressed or answered because all of the expert panels are only viewing the questions that are being typed in the Q&A chat box. Secondly, it is a request to all the participants that you please keep your questions very straight, very specific, and also to the issues that are being addressed at this moment, and not to many other issues that might be very related and connected, but at the moment not very specifically important. So on the question of relevancy of your question, please keep it to the issue at hand, which essentially helps the speakers to also answer it. And lastly, if there is a paucity of time and we are unable to answer all of the questions that have been raised, we will be sharing a link at the end. And in that link, you will be sharing your details along with your questions, and the speakers will get back to you with the answers at the relevant time. So bearing in mind these housekeeping rules, we will now move to our first session, that is to deal with pending FCRA renewals and cancellations right of the NGO. In this specific part, we will have two speakers, Mr. Raja B Singh, who is a chartered accountant and senior partner at R.K. Khanna and Associates. He is an expert counsel in addressing a gamut of national and international issues relating to foreign contributions, foreign funding arrangements, and the like involving society and trusts. Thank you very much, sir, for accepting our invite and for being here to address the gathering. We also have Ms. Manju George, who's been practicing since 1988 and is an expert in NGO management, system controls, management audits, corporate tax planning, and taxation matters. She's also part of the R.K. Khanna and Associates and is heading the Bangalore branch here. Thank you, ma'am, for accepting our invitation and for being here to join us for this. Now, I would like to ask the two speakers to please open up and go on with your presentation, and we will take the question and answer at the end. Thank you very much.
Thank you, Robin. Good evening to each one of you. I am sure that a majority of you here have FCRAonline.nic.in on your browsers, and you're checking status of your application morning, afternoon, evening, and perhaps even in the night. So, you know, there are, but then many of you are probably seeing silence, no change at all, because there are very few who've been granted the renewal, and I'm sure they are not in this group because they are rejoicing and celebrating. And then there are the others, a few others who've been denied or refused the registration, and a good number are perhaps awaiting renewals, and that's probably the major part of this group here. And just to remind you that your application for renewal is made under Section 16 of the FCRA of the Act, and the government is required to make all inquiries that it deems necessary to satisfy itself that the provisions of Section 12(4), which you will hear about as we go on, have been satisfied. So, you know, that's what they're doing. So it's not like they've forgotten your application or misplaced your applications. All of you made your applications online. So, you know, as you're wondering what's going on, we thought this was a nice time to do this webinar. And let me also give you a word of caution here that we will only be talking from the provisions of law. We will only be telling you what is legally permissible, and we will not dwell into anything that is illegal or unethical. And we would like you to be educated on these matters, saying what is legally permissible, because that is what we can do. And so before we move on, I'm going to request Mr. Raja Singh to tell us what do we cover in the next 30 minutes.
Good evening, friends. It's indeed a pleasure for Manju and me and other panelists to be with you on a very important subject of the day. Let me tell you what we are going to cover in the next few minutes. In the first part, that is, in the next few minutes, we are going to cover 4 things. First, we will talk to you as to what you could do while waiting for the renewal. We are all in that same, most of us are in that position, So we would tell you what is it that you should do at this time, apart from checking in the morning, afternoon, evening, and in the night. What is it that you can do? The second thing that we are going to say is that, God forbid, in case the renewal application is rejected and your registration is denied, what is it that you can do? We hope it doesn't happen to you, but in case it happens, what is it that you can do? Well, the third thing that we will cover is, if the registration is cancelled, what is it that we should do? Please remember, your request for registration being denied is different from it being cancelled. The latter one being more serious, and we will deal with that as well, when it can happen and what is it, and more importantly, what is it that you can do in that case. And to make the picture complete, we will also at the end deal with this. If the renewal application was not made by you at all, or it was made but you did not complete it, in the sense you have not made the fees, or you have not done everything, it has not been taken on record, that means it is not done. Not only that, well, some of you have perhaps surrendered it, and in this it has been surrendered. In this we will take it together as a last one. That's what we are going to do today, and we hope it will be an encouragement and you will see clearly what we are going to do. Over to Manju. You are muted, Manju.
Yeah, thank you. So the first part we're going to look at is what happens while we are awaiting renewal. Of course, you are looking at the portal, and just in case you are not, and you're wondering where. Okay. In case you're wondering where where do I look? FCRAonline.nic.in. There are two places that you can look at. You can look at track my application, or you can actually go into log in with your username ID and check the form itself, and you would see a status there. It would either say closed or it would say under process. So if it is closed, there are different from our experience. These are all not there in the law. It's not being picked up from provisions of law. This is just experience has shown us that those of them who've got their status as closed are either on an ongoing inquiry, because it does say that, or it says that it is closed for awaiting MU clearance. MU stands for monitoring unit clearance, or it is that the DIB report is awaited, or there is a report that is awaited by the government from the Directorate of Information Intelligence Bureau, and that's what they're waiting for, or there is a field inquiry that is going on, or there could be even something else. But these are the things that we've generally seen as categories under which we see that there is a status saying closed. Now, not only closed, you may also have an under progress, under process rather, which is that your application is under process, or there are clarifications required. And you might get an email, or you might get, mostly an email, or you might get a letter asking for clarifications. Now, we will go into these things and what we need to do with regard to these matters. Now, Mr. Singh, I would request you to tell us what happens when you say closed. Does it really mean that my application is refused? My renewal has been refused? What shall we do next? Would you please tell us that?
Yeah, when it says closed, it does not really mean everything is over. It only means the initial process of verification is over. That too, initial process. Now, so once the initial process is over, it can move on to ongoing detailed inquiry. It can also move on to being referred to the MU clearance awaited section. That means once you see the status as closed, that's no comfort for you. In fact, you see the remark, and the remark says ongoing inquiry or closed. or MU clearance awaited, which means you can now expect a detailed questioning on the matter. So you need to get ready for that. There could be an audit. There could be a people who will land up at your place to ask questions, or very often you might have a very detailed questionnaire being sent to you. What should you do in that case? Let me tell you, what you need to do is, in that cases, whatever questions asked, be careful to answer them correctly and completely. You know why I'm saying that? You would delay the matter. Don't make them ask further questions. Every question that is asked to you, normally you will get a long questionnaire. Everyone, read the question carefully and give a full question. Be truthful in that and give a complete answer. Don't try to hide anything. That could be dangerous. So give a complete answer. Where they ask for you to give a supporting documents, it could be a voucher that they would ask, do give that. If they are asking you to support the activity, if you have a photograph, you can upload them. So it is important that in case you find them in this category, closed, but with these two matters, I'm taking them together. In these two categories, this is what you can expect and this is what you can do. Now, under closed, there can be a different category. Under closed, in the remark, it might say DIB report awaited, which means Directorate of Investigation Bureau report is awaited. Or it may say field inquiry is on. What does that mean? This is slightly different from the first one where a detailed audit is there. Here, it's more of an inquiry which is awaited, because this is not done by the staff of the MU unit, nor by the, as is now done, some people who have been hired, who are experts, who can look into your account, but this is done by the police department or the CID department, and they are experts in making inquiries, and that's what they will do, and they may not do much of a data verification. Some of them have done the data verification, that's when within their right, and those data verification is normally simple data verification. They would look at your books of account, they will look at your bank statement, they would compare the two, and those sort of a peripheral details is what they would look into. Now, apart from that, there could be inquiries, not necessarily with you. There could be inquiries with your neighbors. Yeah, for that matter, even the inquiries with your enemies. They could inquire with anyone there, there. So, hopefully, they would say well of you. And let me tell you, very often the inquiries are being done with the trustees. So it's only advisable that you brief the trustees. Let it not be a surprise to them. Tell them that yes, there could be some inquiries on that, and tell them, please give the replies. Don't try to avoid it. Don't say you don't know that. Give them fully and give it honestly. So this would help. So as I said, what you should do is, if it is closed, please remember, if it is closed, that means it's, it doesn't say granted, it's closed, which means further either a detailed verification or an inquiry is awaiting. Be ready for that. Be honest in giving that. I hope that's clear to you. Yeah. Yes, Manju.
Thank you, Mr. Singh. So we were talking about, your status being closed. Now, the other status could also be it's under process, and your application will probably say that your application for renewal has been submitted. Now, what are these clarifications? These are mostly coming from, from the government itself, from the Ministry of Home Affairs itself. And these could be just simple things like there are differences in the names of your organization between different documents. The names don't match. The purposes for which you've registered don't match with your documents. Sometimes board members are not even traceable because their addresses were actually wrong. The address which you've given, because they are inquiring about every one of these things and the addresses are not correct and they are different. The affidavit, maybe it's not signed in some cases. Sometimes it's not stamped. Maybe you have not filed your annual returns. So maybe the Darpan ID was not there. I'm just giving you examples of clarifications that could come up. And so you need to just look through, is what we would suggest, look through whatever you've already submitted and see whether there were such errors which are likely to come up. There are even documents which were not in English. Let's say you have documents which were in your own vernacular language, from depending on the state from where you are, but those needed to be translated into English and uploaded. So get ready with English translations of those, of your documents. And remember, be watchful, always be watchful and see whether there are any clarifications being sought. And if they are, honor the time, reply well within time, because if they say 15 days, they close the window sometimes a few hours before you might think 15 days ends. So don't take a chance there. Make sure you've uploaded all the clarifications. At this point, you can't make an amendment. You cannot edit your application form. However, do find out if there were any mistakes. Get ready with the clarification. So as soon as you have it, you can send it over. Okay. So while I've given you broad overview, there are a few more tips, and I'll request Mr. Singh to tell us those tips that can be followed while we're waiting for this application.
What I mentioned about those cases which are closed. Mrs. Manju George mentioned about the cases where it is under process. But let me tell you, in either of these two cases, there are a few things we should be very, very careful. And this is what we have learned from our experience. The first thing that I would advise you is, don't get panicky. Face the situation fearlessly. This is important because, sometimes because of the fear, you could go wrong on this. So there is nothing to be afraid of. As I said, this is just a process, which the government is expected to do, and they are doing their job. And don't take it negatively. They have something against you. They are doing their job, and let's do our job. And that is to give the answers fearlessly and truthfully. Right. Now, I would give you a caution. Please remember, the answers which you give should be in line with all the published materials, including the website. Now, we have come across a few cases where there have been, the website is talking about high and mighty things, but they were not really there in the books of account. Or perhaps the other way around. It could be the published materials. So friends, I would suggest to you, you can't afford to have the difference between this. It has to be truthful. So perhaps, hopefully, your books will be the correct thing. If your website or published materials have to be corrected, please do that. Website, don't tell anything more than the actual facts. Make sure your answers are in line with that, it aligns with that. Now, another thing which is very important is the minutes of the board meeting, minutes of the annual general meeting. There are matters which are recorded there. Obviously, they are truthful things. Now, you need to be aware of what is recorded there. Why I am saying that your answers cannot be different from there. Your books cannot be different from there. So you need to ensure that this correlation is there. I am pointing out these things because we have come across a few people who have come to difficulty because of the variance in these things. Now, if you are asked to describe your activities, do that, but keep in mind for FCRA purposes, there are 5 categories of 5 purposes. cultural, educational, economical, social, and religious. Now, you need to be careful, not any of these 5. Go and look at the registration certificate that has been given to you, the application that has been made, and which are the purposes that you have selected as yours. And your activities fall within that. So in other words, if you have selected economical and your activities are religious, you are in for trouble. If you have selected educational and religious, your activities are religious, yes, it could be all right. So make sure that these things tally. Now, if I can sum up this, I would put it this way, my friend, ensure an overall consistency. Ensure the overall consistency in this. Let me give you a few more things which are very important in this. Now, whilst you do all these things, can you receive foreign contribution? Can you use? Yes, of course. Till that time, you can. So during this period, you are free to receive foreign contribution and you are free to use. But I want to tell you something. You know what? The earlier extension, whenever it was given, you know that the earlier extension was up to December. There, it was a blanket. Up to December, your renewal will expire, which means even if you are denied in November, till December, you could continue the activity. But this extension, the latest extension, has been done in a different manner. I want you to note the difference. And the difference is that it says the extension which is now given is that till 31st March or till the date of denial of your registration, whichever is earlier. That means if you receive the denial today, it applies with effect from today and you can't do anything till next day. All right. So I want you to keep that in mind. But till you hear from them, you can continue to use. Then what should you do? One advice that I can give you is, if you do have money in the bank, clear all your outstanding liabilities. That's an abundant caution. Don't keep anything pending, because the day you get, God forbid, a denial, you cannot touch, you cannot use that. So if you have some outstanding liabilities, it would be good to clear them before that. It may not be advisable for you to pay for the advances unless the advances are paid in the normal course of business. There are cases where we do pay advances, printing you have to do, and sometimes you are used to doing printing and paying it in advance. So only such cases. Don't do anything which is out of the way. But it will be a good idea that you clear the outstanding liabilities and keep the balance so that you are able to face things well. So friends, this covers the first part of our presentation, and over to you, Manju.
Right. Thank you. Thank you, Mr. Singh. So we go on to the next part, which is, not so happy, your renewal is denied or the application has been refused. Now, what does this mean? What happens immediately? What happens immediately is that you cannot receive any more foreign contribution, neither can you utilize the foreign contribution that is already available with you, either in the bank or in cash. So you are not allowed to use this, is what happens. There has to be an immediate freeze on your foreign contribution. So as a matter of abundant caution, you might want to tell your bank that please do not credit any more foreign remittances into my bank account, because if you do, then that would be in violation, because you're not allowed to. Either can you utilize. However, you may note that at this point, there is no embargo on the use of assets. So you can continue, supposing you have a building which is purchased with foreign contribution, it's an asset acquired out of foreign contribution, that does not, you're not denied. You can continue to use those assets. So, so there is no restriction on that. So also, again, we said denial, or if you have, if the date ceases. So if you have crossed 31st March, the same thing will also apply. You've not heard from the department, from the government at all. Everything remains status quo, and the date has not been extended. The due date is as of 31st March, which you just now heard. And in that case, also you will have to stop receiving and stop utilizing foreign contribution. And so what? Now, what shall we do? I'm sure is the question that is on each of your minds. And I'm going to again request Mr. Singh, what is the remedy we have?
Friends, let me tell you, if at all, God forbid, it's denied, you don't have to put up your hands and say everything is gone. You do have a remedy. Let me explain to you what you can do, what best you can do. Listen to me carefully. Perhaps I would consider this as a very important part of our presentation. The first thing that you do is look for the reason for denial, right? The law mandates that the Ministry of Home Affairs, if they deny, they need to convey the reason for the denial to you. So when the communication which denies would also give you the reason for denial, look for that reason. Now, normally the reason is given in the form of the section. So one of the things it can happen is that they would say, all right, section 16(3) is violated. Now, I would think that I have been told that there are some cases like this. That's why I'm saying it. But normally I would say section 16(3) will not in itself appear because it's a general provision, but the contraventions are not in section 16, it is in section 12, right? So in case it says you have violated any of the provisions of the Act, section 16(3), that's what it says, you can definitely ask them by a simple letter, which provision of the Act has been contravened, ask for that. But normally it would say 16.16(3) read with section so and so. Now, in section 12, there are 8 cases of contraventions. But I'm going to talk to you now about 3 very common things which we have seen in the past. One is they would say section 16(3) read with section 12(4)(a)(6), which is you have used the FC funds for personal gains or diverted it for undesirable purposes. Now, if it is out of some misunderstanding, ask them what is it they are referring to so that you can give an answer. So the first question is look for the reason and ask for the explanation on that. Or again, most common till now which we have seen is this, where they say section the clause 7 contravene any of the provisions of the Act. Again, it's not very clear, but that's what they have been doing in most of the cases. Now, yes, do ask which of those acts have we contravened, which of the provision of the Act we have contravened. You must write a letter immediately. Perhaps they may also say F3, and that is this your activity likely to affect prejudicially the public interest in this case. Now, I am not sure whether you can ask them, but perhaps you can write which activity affects the public interest. You can ask. Now, to what extent they would disclose here, I am not sure. But I am, when they say you have contravened a provision, it is for them to tell which provision you have contravened. So now, when many are being denied saying 16(3) read with section 12. Is that the way of communicating? I think as a chartered accountant, I would think it may not, but perhaps the legal experts are the right people to say that. So I would, after our presentation, legal experts are coming. I would request them to say, is this the right way of conveying to them, when we get this denial? Many of them have got like this. And is that sufficient? Is it correct? And what should we do? Well, I would tell you the immediate remedy that you can have is that make an application for revision. I'm saying make an application for revision. Revision goes back to them only, but still make an application for revision. Revision is done, no form, simple plain paper, pay a fees of 3,000 rupees. But remember, do it in 1 year you have, but don't wait for that. No provision for appeal. Now, well, they have denied to you without even giving you a hearing, and there is no appeal. What should you do? Again, I will pass it on to the legal experts to explain that in such cases. Can it be denied without even giving me a hearing on this matter? I would do that. Since there is no appeal, I say, yes, you can file a writ perhaps. More so, very often our experience says the revision applications are not attended to on time. It could be lying there for years. So consider filing a writ if the revision application is not disposed of within a reasonable period. This is what I would suggest to you. My friends, let me tell you, in the meantime, there is something that you can do. Now, remember, what is the stage you are in? You have been denied. And you have asked for the reason. You have filed a revision petition. And, you are considering the other option as may be advised by the legal luminaries. And in the meantime, let me tell you, as a chartered accountant, my advice to you is, by now you would have become a little wiser. You have known what are the pitfalls which are being pointed out. So I would say, sanitize your accounts and records of all the infirmities which you have come to note or which has been in some way conveyed to you. Sanitize your accounts. Make them all right in this. If you have committed an offense, and if it is compoundable, those offenses which involve only an imprisonment cannot be compounded. But if it is imprisonment together with fine, it can be compounded. So, or fine, it can be compounded. So in that case, compound. It's true, compounding fees is very high. Very often it is either 5% or 10% of the amount involved in it. But still it would be worthwhile. You apply for it, that the compounding, you do that. Do compound those offenses by paying 1 lakh or 10%, whichever is higher of the amount involved. It's still worthwhile if you do that immediately. And then, you know what, my friend, as I said, don't lose your hope. Make a fresh request for grant of registration. Yours has been denied. Take these corrective steps. And there is a provision to make a second request. You can do that. So don't give up your hopes. You can still sanitize, you can make the correction, compound the offenses that have been committed, and then make a fresh application for grant of renewal. That completes the main part of it, what you can do in case it is denied. Well, over to you, Manju.
Thank you, Mr. Singh. So, so we all heard now that denial does not necessarily mean that the end has come. Yeah. But however, the cancellation is almost like the end. It is not a place where any of us want to get to, because it does mean that, it is an absolute end. So till now, as of now, if you've got denial, if you've got no responses, please note that there is action that you can do. And so, do it. But so what about cancellation? Let's see what about cancellation. And you will remember I mentioned that the renewal was made, application was made under section 16, and where the government has the right or is required to make inquiries whether you have contravened any of the provisions of section 12(4). Now, having done that, and likely that if you have a denial of renewal of registration, it is possible that they might move on to a cancellation after making further inquiry. So please note that it is under section 14 that cancellation is done, and the government makes further inquiries. And these are the conditions under section 14(1). It might seem like more or less similar, but it is a different proceeding altogether. So the cancellation proceeding is a totally different proceeding. So they will have to initiate it and go through the process and satisfy themselves that there has been incorrect or false statement made by you, that there were terms and conditions that you have violated. Again, it is necessary in public interest that you have violated provisions of Act rules or order, any of them are violated, or you've not been engaged in any activity at all for 2 consecutive years. But the good part of a cancellation, it doesn't just come to you one fine day or email one fine day, but you have given an ample opportunity of being heard. So which means you will get a notice, you will get what we call a show cause notice, and they will tell you are the areas where they think that they have found which you need to give a reasonable answer. Okay, so let's now again go back to Mr. Singh and say, how serious is this and what consequences should we expect?
Yeah, friends, yes, as Mrs. Manju George has said, this is something which we would not like to have, but there it is. If it is cancellation, that's, under this, one of the worst that can happen. Well, what happened? What exactly is this? The first thing is, all the FC funds and the assets created with the FC fund shall vest with the additional chief secretary or the principal secretary home of the state government. Now, I want you to say, you know this, because I know people have been talking about, well, all my assets and money will be confiscated by the government, which is not correct. Please understand. Confiscation is different from vesting. It just vests with them. You will get that clear as I go further on this matter. It is not confiscated, it vests with them. Why it vests with them? You know what? Interestingly, the authority is expected to manage the activities and of this your organization. So it is something like you hand over the baby to them, right? And of course, it is provided that if there is not sufficient money for that, then they may dispose of the assets there, which is there. So authority may manage the activities and may utilize the we may utilize this money if it is not possible. Yes, if there is not enough money, they may encash that. Now, this is the hope is here. You know what? It says the government, it has vested on them, shall return the FC funds and the FC asset if the organization is subsequently registered. So I want to tell you, my friend, that this is not the end of the world. Even if there is a cancellation, you still have hope. Steer well clear of it, then you can go. So even in this case, I would suggest there is hope. What should you do? Let me tell you what you can do is this. If it is cancelled, yes, consider preferring an appeal. Appeal is provided to the High Court within 60 days. You can do that. Now, well, appeal has its own effects. Apart from the cost, there are other effects on that. You need to do that. It may affect you taking the other step, which is a re-registration, I'm going to tell you. But how good, bad it is, let the legal luminaries explain to us. And now, re-registration is possible, but after 3 years. So you have a 3-year window. Don't lose hope. Do whatever is required, as we would tell you. After hearing the legal luminaries, you will be able to make up what can be done. So if there is a cancellation, you can still apply after 3 years, but in the meantime, you may consider making an appeal. I said, consider it. Well, having said this, I must add this. There is something called suspension. What is that suspension? Suspension, though not necessarily, often a forerunner of cancellation. So you need to be careful. If the government is satisfied that it is necessary so to do, they may, pending consideration of cancellation, they may suspend the registration. Well, if they suspend, the suspension is normally for 180 days and they have a right to extend it for another 180 days. That means for the next 1 year, you are immobilized. That is true. You cannot receive foreign contribution during the period of suspension, except that you can apply for, get the permission, and up to 25% of the money you can use for that. Other than that, you can't do anything. During this period, there will be a lot of inquiry. Answer them well so that it doesn't slip into cancellation, so that you can arrest it here and then you can restore it back. Hopefully, it will be restored back to you. So if there is a suspension or a cancellation, don't lose hope. There is still a way out. You need to steer clearly. I hope you will be able to do that. That takes us to the last part, and I'll hand it over to Manju on that.
Thank you, Singh. So we've come to the last part. Now we were talking about making an application. You've made an application for renewal. Now, what if you did not even make an application for renewal, or perhaps you chose to surrender? You said, "Okay, I don't want this FCRA registration at all," and you chose not to apply, or you made an application for surrender, which is a process in itself. Right now, let me tell you something, that this is as bad as a cancellation in terms of position. It is as bad as cancellation, because the consequences of surrender or not applying for renewal is exactly the same as Mr. Singh just now explained in the case of cancellation. Now, for want of time, because we want to leave more time for question answers, I'm not going to go into this, because this is exactly the same position that you would be if you were going to be getting cancelled. So we will move straight into remedies. What remedies do we have, Mr. Singh? Would you tell us about remedies if there was no application made?
Let me tell you the remedy if the renewal is not applied for. Now, I want you to know, I'm not telling you the remedy if it is surrendered, because there is no remedy really, because you yourself have surrendered. So there the matter ends. But if you have not applied for, then of course, as Mrs. George explained earlier, it ceases. But you know what you can do is, my friend, you can make a fresh request for registration. You can do that. You are allowed to do that. So even if you have not made the application, what you do is immediately make an application again for this, but make it by giving a sufficient reasons in writing for explaining why it has been delayed. Now, this has to be done on a simple plain paper. You need to make that. You need to pay a fees of normal 5,000 and an additional late fees of 5,000 rupees. You need to pay and you can make it. So my advice to you is that if this happens, you can still, look for making an application, paying an extra 5,000, and then getting on the go on this matter. So friends, we have covered by now all these three aspects, but this is what I want to leave you with. While awaiting what you can do, if the renewal is denied, you may not like it. If the renewal is cancelled, if the renewal application has not been made, don't lose hope. Don't lose hope. There is still a way through, and you can drive through this. Yes, we will finish it here and hand it over to the moderator, and we will come back to answer your questions, if any. Thank you very much.
Thank you.
Thank you, sir. Thank you, ma'am. Thank you for that wonderful presentation. It was straight. There's a lot of absolute clarity and understanding. And I'm sure anybody who has kind of at least keenly listened to it has clearly understood a large part of whatever you have tried to communicate so effectively. Thank you for that. We would also kind to inform to all the people who are participating in the webinar that we have about 395 participants who are at the moment logged in to this EDF India hosted webinar on FCRA renewals and cancellations. So thank you all. And now, without much delay, we would like to go into the second part of the presentation, which kind of flows from where Mr. Raja Singh and Manju George have kind of left us. That is to explore what are the legal options that are available. In order for us to kind of help, think through this particular subject, we have with us Advocate Abhishek Jebaraj, who is a partner at Isaac and Jacob, which is an Indian law firm. He's also been doing very important commercial and constitutional law practice and appearing before many of the courts and forums across India, and was also engaged in important pro bono work, which has been primarily towards promoting human rights in India. Thank you, Abhishek, for accepting our invitation and for being here. And now we would like to ask you to go ahead with your presentation, following which we will have Tehmina, who will take us forward on the next part. Just a small housekeeping thing. Once again, just to reiterate for the benefit of those who have joined late, we are only taking questions which are specifically typed into the Q&A chat box and not into the regular chat box. So if there are participants who have specific questions, please see that in the screen below, you will find a chat sign which says Q&A. which is specifically there for you to ask your questions. So please type in your questions. And secondly, in the light of the discussions, please keep your questions relevant. Thank you, everyone. And now I would like to ask Abhishek to please carry forward. Thank you.
Thank you, Robin, for the introduction. And I hope I'm audible to everyone here. Also grateful to ADF for organizing this webinar. And Mr. Singh and Ms. George have taken us through quite comprehensively through the various provisions, technicalities, the things to keep in mind, whether it comes to renewal, cancellation, and making applications. And just, to kind of pivot off what they said, it's important. I know there are so many organizations, people here on to this evening, and a lot of you have been doing have been doing a lot of genuinely good work, dispersed across so many areas, whether it's feeding the poor or providing care to orphans. And our goal is to come alongside and make sure that you have the resources to ensure that you have strong legal compliance and strong knowledge on how to make applications and have your finances in order, so that this administratively helps support the work you do and helps you scale as well. Now, when it comes to remedies under the law, let me just give you a very broad framework. Now, as far as the FCRA is concerned, there are certain rights or there are certain remedies available from the FCRA Act itself. That's called a statutory remedy. And there are certain broad scope rights that are available under the Constitution. And so an organization has the right to association. It's a fundamental right. An organization has the right to equality. That's a fundamental right. And that's on another level as well. Now, whenever the government is involved in taking any administrative action or deciding applications or administering any act, there are broadly three kind of principles to keep in mind. Whenever any government action is taken, is one, you should have notice of the action. Secondly, you should have a right to be heard. And finally, you should know the reasons for why a certain action is being taken. And if you look at the FCRA Act, you will find that's the gold standard in law. When any administrative action is taken, you should have notice, you should have a right to hearing, and you should know the reasons. Okay. Particularly if it's drastic administrative action against you. And you will notice that these three principles are enshrined, whether it comes to suspension, renewal, or cancellation in some form or manner. When you look at cancellation, because the action is so drastic, the Act under 14.123, you look at them together, they give you all three. Unfortunately, you don't have all three available when it comes to suspension. You don't have all three when it comes with regard to renewals. So with renewals, you will have your reasons. When it comes to suspension, you'll obviously get some form of notice. You may not, you're not going to get a right to hearing for sure. And reasons, well, not really. You may have some idea of what they're doing, but you may not get that formally. Now, why am I saying this? Because when you look at the structure of the FCRA Act and your remedies, a lot of them depend on these three factors. Okay. So for example, and I'll talk about why this procedure is so important, is because when it comes to cancellation, it may look like a dead end, but if one of these three have been flouted, you may have a fair remedy. So procedurally, what of these three principles was the government supposed to afford you under the Act? See, if it's a suspension, are you even told of your suspension, or did you just get a bank, did you just get your funds frozen with having no clue as to the fact that you've been suspended, what the reasons are behind that? If it's a renewal, have you? And now we'll get to the part where some of the reasons are also vague. But the first thing to ask yourself is, do I even know why? Just very generally, has anything been communicated to me at all? So keep track of these three principles as you go along. Now, where are my remedies available? Broadly under the FCRA Act, the FCRA Act broadly, you'd have a remedy before the government and you'd have a remedy before the court. Okay. Now, when you have a remedy before the government, sometimes it's not something, it's not your revision, but like was already shared earlier, the government may ask you for more information, the government may ask you to clarify something. And so there's a level in which you're seeking remedy directly before the government by making a certain representation. Please always, just a principle to keep in mind, be respectful in your communication, and also make sure that it's written, because often when you want to backtrack over records, you say, oh, I just spoke to an officer, or I went down and I met someone. But as far as possible, do make sure that all your communication back and forth with the government is clearly documented, recorded, and is respectful. That's going to be important if you're taking clarifications back and forth, or if it is something that can just be sorted out by working with the government in administration, in communication. Now, if you need to file a revision application, note that the revision provisions under the FCRA Act are very, very broad. So it almost says, it in fact says, for any order passed by the government. So it's very, 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 very broad. If you have a cancellation, you could go on for renewal. For a revision application. If your renewal is denied, you can file a revision application there as well. Now, as already told to you, you should note that the government is a biased party in a revision application. By the word biased, I'm not saying officers are biased. Obviously, they, objectively supposed to look at things. The law recognizes that they're not neutral parties, because it is the same central government that's deciding your application. And so in that sense, they're a quasi-judicial authority, and some of them in the department may be involved with the case, right? So with a revision application, there's that disadvantage that you have, and also the fact that it may take time. It's not a court of law where things function in a purely judicial capacity, and therefore things may take time. Now, if things are taking time, you could obviously go to a court of law. Now, let's look at some of the judicial remedies that we have, right? And one was touched upon, is that if your revision application is not being decided in time, then you could simply go to the High Court and make sure that you get an order to expedite your revision application, or that it's heard in a time-bound manner. Tehmina will probably share with you examples of cases in which that's been done. So that's one remedy that you can do. Now, I would suggest always moving a revision application before you go to the High Court. The reason being is that there's a principle in law that before you go to the High Court, you want to exhaust all your alternate remedies. So do make sure that you're writing representations to the government, make sure that you exhaust your revision. So let's look at this in terms of hierarchy. If you have a problem or an issue, the first thing you should say is, have I made representations to the government? Is this something that I can sort out before the government? That doesn't work, then you look at filing a revision application. If that doesn't work, you go to the High Court. Okay, so this order is important because it's important to exhaust your alternative remedy before you go to the High Court. Now, when you are before the High Court, obviously, you could get an order to expedite your petition. Now, the Act itself, and this was also touched upon, has an appeal provision before the High Court. Now, the reason why this is not used very broadly as what you call a statutory appeal, and the reason is the Act actually says that it applies to organizations of a specific nature. It says organizations under Section 3, Section 6, or Section 9, which are certain categories. For example, they may have a political tenor to the organization and things like that. And that is the reason why the statutory appeal seems very narrow. So there's a provision in the Constitution under Article 226, where you can go to the High Court if you are aggrieved by the government taking illegal administrative action, or any action is not in conformity with any law. And that is the provision that you can use. Now, there are broadly certain grounds on which you can move the High Court. And these grounds really are that, one, the procedure wasn't followed. Okay, so look at it this way, that the notice that we talked about, the right to hearing and the reasons, this is not being afforded to you. Okay, the second is what the ground of that action was, right? So first is whether the procedure was being followed or not. Secondly, even if the procedure was followed, is that action in conformity with the Act, that's your statutory rights, and your fundamental rights. That's why I broke it down in saying there's a procedural law, and lawyers use this term substantive law. Okay, but substantive law means the provisions under the Act generally and your fundamental rights. Now, there are several reasons that we're seeing repeatedly given. Some of them may be very specific in your denial, but if you're seeing provisions like violated any provision of the law, or if you're seeing something like against public interest, again, courts have ruled generally that when you give reasons, they shouldn't be vague, they shouldn't be overbroad, and they shouldn't be illegal. Okay. By vague, it's a provision that really you have no idea as to what the boundaries of it are. It's something, for example, public interest. That could be something that is really detrimental to government interests, or it could be something that's is actually helping the public. So public interest means different things to many people, and therefore courts sometimes would like to go more narrow and say, okay, how is it actually violating public interest? So that would be something that is vague. Something that is overbroad could be violating any provision of this Act. You see, the Act has, you could be receiving money for terrorist funding, and that's something that's very drastically wrong. Or it could be something that is as minor as maybe you didn't file your annual accounts on time. It was 2 weeks late, right? Now when you say overbroad, it means the government is taking such a action of cancellation equally for all offenses, whether they are major offenses or minor offenses. And that sometimes the court frown upon, because there's a principle that your punishment or your action should be proportionate to what the offense was. So when they say you've contravened any provisions of the Act, in fact, that's a good example of something that's both vague and it's overbroad, because you don't know what provision of the Act, and it could be something that is very disproportionate, right? It could be something very minor and you're facing a cancellation. In fact, we have seen that against a few organizations where for filing delayed accounts, they've been cancelled. The third reason is something that is absolutely outside the ground. So if you feel your organization has been cancelled, some reason has been given to you, and you feel that this doesn't fit in any of the grounds of 12.4, I mean, how is it even wrong, right? So if they say, I'm just giving a very bizarre example, but you're functioning in the state of Tamil Nadu or Karnataka, I mean, that's just not a ground for which it should fall under the Act, right? So that would be an illegal ground. That's another ground that you can take. Okay, so very simple. Let me just sum up some of the remedies. One, make sure that you are first making representations to the government. And as Mr. Singh and Ms. George said, please rectify your defects first. Make sure that everything is in order. Your accounts are sanitized. Make representations to the government. If you still feel after doing that you've been aggrieved, the remedy of revision under the Act is a very broad remedy. Please make use of it. One important thing to remember for that remedy is that it's time bound. You have a limitation period of 1 year. That means that within 1 year of which an order was communicated to you, you should have moved your revision application, because the government can condone this under certain circumstances, but don't expect that. So move your revision application within a fixed level of time. If your revision application is not being decided, it's just lying there for 6 months, 1 year, you could go to the High Court and just get an order to expedite it. Or if your revision application has been denied or dismissed, then what you do is get into an analysis of what your remedies before the High Court are, and you can move a writ petition. Your remedies may be procedural under the Act, or it may be that your reasons are vague, overbroad, illegal, and you could always tie it into a violation of your fundamental rights. It could be your right to association, your right to equality. If you're a faith-based organization, it could be a violation of your religious rights too. These could be looked at. So on that note of just providing a broad-based overview on legal remedies, I'll now hand it over to Robin, and I know Tehmina will take you through the next part of kind of an overview of what we're seeing in court practically based on these legal remedies.
Yeah, thank you, Abhishek, for that wonderful gist of giving step-by-step and way of going forward. In case if somebody is facing a difficulty or is in a situation and is in need of a remedy. So now we'll be going to the last part of the presentation, where we'll be looking at a presentation which is essentially looking at some of the petitions that are pending before some of the courts in India. And to share with us on this particular issue, we have Tehmina. She's a very well-known person to all of you. She's a director of EDF India, and she's also a lawyer who is practicing in the area of constitutional law and human rights. And without much further delay, I would like to ask her to go on with the presentation so that we have a substantial amount of time for question and answer session. Thank you, Tammy, for being here, and I would like to ask you to go ahead with the presentation.
Thank you very much, Robin. I got from your tone that I needed to keep my presentation short so that we could move to the questions, and I will try and do that, be mindful of time. I just want to share my screen, and hopefully you can see that now. So I'm assuming you can see the screen now.
Yes, Tam.
So yes, I'm hoping to take another 10 minutes or so. So I'll just walk you through some of the judgments that are coming. And I've divided them up into various categories, but really essentially what there are is bad news, good news, and other news. So that's what we're going to be trying to look at. In the area of suspension, I'd just like to highlight one particular case that came up fairly recently. It's called the Commonwealth of Human Rights Initiative and versus Union of India. And what we saw in this particular case, that the organization FCRA registration was suspended, and soon after they received that registration, the suspension order, they moved the High Court asking for a stay in that particular suspension. And the lawyers appearing on behalf of them submitted that Section 13 in particular requires, as Abhishek was just explaining, a recording of the reasons. And that since no reasons were recorded here, that this particular suspension order should be stayed. The government countered this, saying that the suspension order was actually reasoned. Why? Because it highlighted 2 or 3 instances where the organization had failed to upload annual reports, had used the purposes, the FCRA accounts had sent back money to the donor, and it highlighted a couple of issues like that. And that the opportunity to be heard was not provided under Section 13, but rather only under Section 14. So the reasons had been outlined according to the government, and the order was valid. And the Honorable High Court actually upheld the suspension order and said that given the possibility of grave violations here, a suspension order was in line. It is an optional step, but it was in line in this particular thing. And it also said that the fact that an inquiry had been initiated way back in 2017 could be counted as one of the reasons or notice of such suspension, moving on to even perhaps cancellation of the organization. So definitely not so good news here for the organization. They're looking at this particular matter in courts, even now hoping to file an appeal. The other issue is on renewals, and cases being highlighted by various speakers before me, but moving revision order under Section 32. And in this particular case also, the organization had applied for renewal. It had been refused. They filed a revision order way back in 2019. So I'm just trying to talk about timelines here. And in spite of getting a hearing, the revision remained, the order remained largely pending before the ministry. In 2021, the organization moved to High Court, filed a writ petition before the High Court, and asking for a speedy disposal in a time-bound manner. May their application be decided. The court directed that yes, it should be decided in a time-bound manner, given that there was a long pendency here, and gave the FCRA department 3 months to comply with the order. Unfortunately, the FCRA department failed to comply. The organization goes back to the High Court and again asks for the matter to be expedited. And what the FCRA department did here was very interesting, that they said that the refusal order was set aside and they were going to decide a fresh application. So the refusal order being set aside, and now a fresh application that was being made for the FCRA certification. So this was both using section 32, the revision order, but then also getting the High Court in a time-bound manner to decide these matters. A very interesting case coming out of the Delhi High Court, double bench. I can't get into the facts of this case, but the last hearing on the 16th of December, the question before the court was really that, can an order of refusal, refusing a renewal under Section 61 be granted without can be given, without the petitioner or the organization being given a hearing? So can you be refused without even being heard? And the High Court said no, and the government actually agreed to this. The High Court says no, the organization should be heard. They should have an opportunity to be heard. This is natural justice that requires an opportunity for hearing. And so in this particular case, the organization has that opportunity. And the court also said another very interesting fact that, that even if an adverse order is given, that your renewal is refused, that it would not come into effect for another 2 weeks from the date the order was served. This allows you some time to, in a sense, go back to the High Court or take next steps of action. So a very interesting order coming out of the Delhi High Court just in December last. Another petition coming from Andhra Pradesh, where the petitioner running a charitable organization, several lapses on their part, had not filed their annual returns on time. There was a cancellation order against them. And then subsequent to various notifications that were put out by the government from time to time, calling for organizations to submit, but also compounding, which was referenced by Mr. Singh previously, compounding of the offenses. So this particular organization asked or paid up the fine, got the offenses compounded, and resubmitted all their resubmitted an application. They were told, unfortunately, because of the previous violations, they would not be granted on FCRA registration. They also moved the High Court, and the High Court was pleased to allow their writ petition, and in fact ordered that they be granted their FCRA registration, because they had those penal provisions could not be held against them because they had been compounded. So very, very interesting decision coming out from Andhra Pradesh. I think this was in September of last year. Looking at the penalties and some of the non-filing issues, we've seen that several cases where, because of the delays in the opening of SBI accounts, there has been penalties levied against organizations because they've not been able to upload their annual returns in time. They have not been able to provide information about their SBI account and causing delays. So in this particular case also, there was a delay like this. A heavy penalty was levied against them. The organization challenged that. And in the High Court here in Delhi has said that no coercive action should be taken against the petitioner. The matter is pending before the courts. There are a couple of other matters which I think would be very interesting for us moving forward. This is a decision that is pending before the Supreme Court of India. There's a challenge to the amendments that have been filed, the FCRA amendments. Several articles have been challenged, or several sections have been challenged under Articles 14, 19, and 21. The judgment is pending in this particular case. Their parties have filed their replies, and we're just awaiting a judgment here. This will look at some of the key provisions under the amendment, and I think this would be something that all of us should be watching for. There's another petition pending before the Orissa High Court, again challenging very key provisions, and I am sorry that the font is rather small. You will be able to receive this PPT, but it's talking about the transfer of foreign funds between organizations, the reduction on administrative expenses, even the mandate before the SBI to open this designated account there, and even the provision of vesting of assets if you have surrendered your FCRA. So very important questions of law in both this and the previous petition that I mentioned. This matter is also pending before the courts, and we are waiting news on this. I'd like to just finally point to the fact that if there are questions, and I know several have already been asked, but there may be additional questions that you may have, please feel free to write to us at askme@adf India. If you require any training or consultation, we'd be happy to provide those services. We're also happy to be able to provide some legal referral services, where appropriate, perhaps even pro bono services, because we recognize that several organizations find themselves in a flux just now, and we're happy to be able to provide some support. So sorry for this rushed sort of thing, but so that we can just quickly get to the questions. And this PPT will be shared. Thank you.
Thank you, Tehmina, for that very crispy presentation and keeping it so short. So we have about 40 questions that we have received in the Q&A chat. What I will do is I will just read it out, and the experts could, answer them. The first question that has been posed here is, if FCRA of an NGO is cancelled, can the board members of this particular cancelled NGO be on board of a Section 8 company? Mr. Raja or Ms. Manju George, if you want to answer this question. Whether the question is, if the FCRA of an NGO is cancelled, is there any liability on the members to actually be on the board of another company?
Yeah, if there is an organization where I'm on the executive committee and the registration is cancelled, then there is some disability, in the sense, even when the questions are asked, there are questions which is asked, or any other organization where you are associated, there have been a cancellation. So in other words, this could be a negative factor on this. So yes, once you are in one organization where there is an issue, it could be considered negative in this. That's not the end of it, but it could be considered as negative. Yes.
Thank you, sir. After the DIB report, how long does it take for the renewal of FCRA? So is there a timeline that can be drawn, is a question.
Yeah. You see, DIB report is seen to be taking really a lot of time. And so the whole matter is pending. Now, in any case, they have to give you an answer before the date which is prescribed, 31st March. So that's a date by which, everything has to be completed and you need to have that. Now, the point is, well, it can get extended. 31st March, I don't know, with so many cases pending, is there a case, will it be over? I have my doubts on that. So unless it is extended, there you are, you will get an answer by 31st March.
Yes, sir. Thank you for that. One more question. I think many of these questions are basically rooted at you and Ms. George. Can an NGO which has got its FCRA renewed take over another NGO which has its FCRA either cancelled or suspended?
Can an NGO
which has received an FCRA renewal can
it take over another NGO? Certainly, it will be frowned upon. Certainly, it will be. You see, your registration has been cancelled, right? So you are told that you are not eligible to deal with the FCRA. So the question of, in fact, how do you take over itself is another issue. But the thing is, once it is cancelled, stay within that. Don't try to manipulate by, passing on the money to somebody else, or, getting on somewhere else. Don't do that. Look at the ways how you can do that, rectify things, get in order, apply the legal remedies, and don't look for these shortcuts, would be our advice to you on this.
Okay. Can I? Sorry.
I think, sir, the question is the reverse. It is if an organization has received their FCRA or their FCRA has been renewed, can they take over another organization whose FCRA has been cancelled or the renewal has not taken place? So not that the organization whose FCRA was cancelled is taking over the other, but rather the other is taking over the one that was cancelled.
Yeah, so, thank you, Tehmina. You see, the same principle would apply. The organization whose registration has been cancelled, that's now getting into some other organization, which should not be considered. Your activities have been prohibited. You cannot do that. So you cannot go under the cover of another organization. In fact, or you cannot even start another organization with the same set of people involved in it. So either doing it in some other form or getting in under another organization, both would be frowned upon.
There is a question which pertains to, maybe Abhishek could answer this. That is, nothing was given in writing that, it is denied. But when they checked on the website, it displayed that it was denied. So what is the recourse?
Right. And this actually raises an interesting question of law. And it has been raised in one of the pending cases involved in, is what constitutes a fair notice, right? Because there were some organizations, for example, that received notice of cancellation as an SMS message, which they never got. And can you give an en masse cancellation notice online? Now, the way I view it is that is not a fair notice and an opportunity to be heard as far as Section 14 is concerned. So that could possibly be a ground. But it would also be important for the organization to still see, based on what is online, whether they can find some reason. Because sometimes, even, I mean, not just sometimes, always, if there's a notice online, there will be some reason. So even if it's en masse, for example, they'll cancel 1,000 organizations who have not filed their returns in time. So you may not have a strong case if you go in just with saying the form of notice was not adequate. Also get into your reason, and then you could possibly pursue legal remedies depending on that.
Okay.
Mr. Christopher, there were a few questions which were asked earlier. Would you?
Yeah, I'm just going to that, sir. I'm just going into that now. Yeah. There's one more question where they're asking what happens to the assets and unutilized funds if nothing is heard till 31st of March.
Manju, would you like to cover that? That was a portion which you covered.
Yeah, we did cover that. So, as of 31st March, if you haven't heard from them, your registration is deemed to have ceased. And so you cannot use your foreign contribution nor receive any foreign contribution beyond that date.
Okay, thank you for that. There is a question that is, if assets were brought for a project, but the project has closed during lockdown, can you sell the assets, and what is the procedure?
Yeah, if your registration is still alive, your registration has not been cancelled, then you can sell your assets. Yeah, you can do that. However, what you need to remember is that when you sell the asset, the proceeds are also foreign contribution. So they have to go back to the foreign contribution account. So if the registration is valid, yes, you can sell that. Now, there is another very interesting question. Which account will it go to? We have a SBI account, which is for receiving the remittances, and you have another FCRA account, right? Which account will it go to? There is not much of a clarity on this. However, if you study the charter, FCRA charter for the banks, there you get that inclination on this. There, according to that, based on that, I'm telling you that any foreign contribution received by way of a donation in India or in rupees should go to the SBI account in Delhi. However, a sale of an asset proceeds should go to the additional FCRA account, not to the account where you receive the remittance. So to answer specifically, yes, you can sell, but remember that the proceeds come into the additional FCRA account.
Thank you, sir. So there's another question where there is an organization which has not received the funds from February, and they're also not able to locate it till now, though there is an acknowledgement that those funds were transferred into their account by 4th Feb. They want to know what can be done in such a situation.
Well, this is a procedural matter. It's not really a legal matter as such. It's a banking issue. You need to take it up with the bank. So don't engage Abhishek to fight this. It's a procedural matter. you need to take it up with the banker.
Okay, thank you, sir. Thank you for that. Is there an issue in keeping a person born in India but now is a US citizen holding OCI card to be a chief functionary?
Oh yeah, that's you know, he's a US citizen. You know, that's what the question says. Born in India, that's okay, but he's a US citizen. And now that you hold OCI card is a different matter. Now, I want you to know that generally, any foreigner being on the executive board or being a chief functionary is not permitted, generally, right? Now, this is not in the act, this is not in the rules, but this is very clearly answered in the, given as an answer to one of those frequently asked questions. So it says generally it's not permitted. However, if he is an OCI, foreigner is an OCI, and in a few other cases where he is married to an Indian, or if he has been in India for the last 5 years, and if he has been, he has a specialized knowledge on the matter which you are involved in, particularly if it is a health and medical matters, and if he has been giving a service, honorary service all these years, then again, you need to take the permission, and it says it will be decided on a case-to-case basis. So if you have a US citizen who is an OCI card holder, then not without getting the permission. You need to get the permission from the Ministry of Home Affairs, then he can be on the executive committee, or he could be a chief functionary, not otherwise.
Thank you, sir. There's another question which is very connected. That is, can two FCRA organizations have the same chief functionaries?
Once again, there is no legally, in the law, there is no provision, in the act rules, there is nothing. For that matter, even in the frequently asked questions, there is none on this. Now, however, let me explain it to you. What does it mean, chief functionary? You know, the moment you say chief functionary, he is chief functionary looking after the functions of that organization. So the moment you say chief functionary in two organizations, there is an internal contradiction on that. And these are matters which would raise eyebrows in the Ministry of Home Affairs. So though there is no specific prohibition, you know, this will not go well with the Ministry of Home Affairs. And I would suggest to you, don't do that. Don't follow that.
Thank you, sir. There's another question that is, what if the property is purchased using both local and foreign contribution funds?
If both a property with both the local and the foreign contribution purchased, good, yes, you can have that, enjoy, use, as long as your registration is on. Okay. The issue would come when you sell it. When you sell that property, there is a reference in some one of those charters which says when you sell the property, the entire amount should be deposited, but that doesn't appear to be correct, because you know the portion relating to foreign contribution can go there and the rest should go to the local funds. That's, you know, in consonance with the law. Now, the issue can also arise if your registration is cancelled and the property vests. Now, it depends what the property is. If it is a motor car, you know, would you like to give this, you know, some part of it, the front portion of the car goes to FCRA and vest and the back does not? Obviously, it's illogical. The building, perhaps, you know, you might be able to say a A wing and B wing. If it is A wing was foreign contribution, B wing was local contribution, you can divide that. But if otherwise, there could be an issue. These are the things which you are going to face now. Frankly, I don't have an answer on this. As we go along, we will see how things are. It's not so easy. We will have a very difficult or very challenging time ahead. But the consolation is we have good legal people with us to advise us in all these matters.
Yeah, thank you, sir. The next question is, can various organizations together challenge the FCRA cancellation, or does it have to be individually?
Tehmina, would you like to handle that?
Yes, I would definitely advise that each challenge should be individual. It would allow you to speak into that specific situation rather than broad base it. I know there's some trepidation about moving the courts when you have FCRA registration, but considering this is a cancellation, I would definitely recommend that. But like was shared with, by Abhishek, please exhaust the remedies that already exist before moving the courts. You must try and do that. Make your applications, make sure all of that is submitted first, and then subsequent to that, move to courts.
Right. Just to quickly add to what Tehmina was saying, that it would not be advisable to move a public interest petition on behalf of many other people's issues that they're facing. What you can do, though, is if individually each of you are facing the same issue, you can go in a common writ petition to the courts. That again, is something that's done often. And if you want a little bit more of an associative support, you can do that.
Yeah, thanks to both of you. The next question is, what is the procedure that the Ministry of Home Affairs have when they receive any false complaints about NGOs? Is there a procedure in place that they would follow is a question.
I wish we had somebody from the Ministry of Home Affairs to answer that. We are told that they are making an impartial inquiry. But the experience shows that even some of the false complaints have even gone to the extent of suspension. I'm saying it from my experience. So what is the system that they have? I'm not privy to all those matters, but it's a matter of worry that someone can make a false complaint. And even that could be taken seriously by the Ministry of Home Affairs. And the only hope is that in the inquiry, we will be able to counter it, all those. That's a hope. So when we get an answer, when you are asked upon that, give a specific, clear answer to disprove that if it is a false complaint, And of course, if they still go ahead, if it's a false complaint based on that, we may have to look for the legal remedies on that.
Thank you, sir. The next question is it legal for a non-FCRA NGO to receive funds from FCRA NGOs?
Oh, certainly not. It's very clear, those days are gone. There was no days, in fact. Even two FCRA organization, two organizations also cannot transfer one to the other. That was a old provision. So an organization, an FCRA organization who receives the fund cannot transfer to another organization, whether they have FCRA registration or not. They cannot have that. So please keep that in mind. That will be a serious violation again.
The next question is with regard to the donors. That is, if there is any problem for the foreign donors of one organization whose FCRA has been cancelled, can they send their contributions to another organization that has gotten their FCRA renewed?
Well, if they are a foreign contribution, they are not able to send to one organization. If they choose to send to another organization, yes, they can, but it cannot find its way back into that first organization. Yeah, that's the only thing. You see, this organization has been prohibited. So please understand, don't try to maneuver that. You see, this is where, we need to show that in the past, we have had some cases where it has been denied, but they were seen to be following some other methods of doing the same activity in some other name or in some other form. And that has not been taken well by the Ministry of Home Affairs, and they had come with a very heavy hand on those matters. So if, someone sitting there, well, I want to help India, I'm not able to do it here, and I'm going to give it to another organization because they are doing equally good work and they do that, and that money is used for that organization, then there is no problem on that.
Thank you, sir. The next question is, if assets have to be sold, does the Act mandate any procedure of getting any approval, or can it be done by the organizations themselves? If assets have to be sold.
If assets have to be sold, then, obviously you require the approval of the board. And under the FCRA, you don't have to take an approval unless the property is vested. You don't have that. At this, you don't have to do that. Of course, there are other laws like in Maharashtra, you have under Maharashtra Public Trust Act, you cannot sell a property without the permission, getting the permission of the charity commissioner. So under FCRA, you have a valid registration, you have a right to sell the property, but as I told you, follow the subsequent procedures.
Thank you, sir. There is a technical question that is, do we need to show interest on fixed deposit in quarterly filing of receipts?
Manju, would you like to take that?
Do we need to show interest on fixed deposit in quarterly filing of receipts?
I would think if first of all, the interest should be interest on deposits made out of foreign funds. So, foreign contribution. So if that is an interest, which is a foreign contribution, and you've earned it, you've received it during the quarter, then you definitely need to show it so that your annual returns also match up with your quarterly.
There is, a lot of these questions otherwise were quite, repeating on the same aspect, but I think I like to ask a question of how do you think, Abhishek, are the courts looking at, some of these cases or petitions that have been filed by organizations? So how do we actually read the judiciary and the way it is actually responding to a lot of these challenges? That might be something that we would be interested to know. Yeah.
Right. So one, the judiciary is certainly making sure that they are holding the government accountable on procedure. We are seeing that repeatedly, and just like the case that Tehmina pointed out, I think it was the Insaf case, the courts are very strict on procedure. Now, when it comes to grounds of cancellation, generally the courts have been very deferential when it comes to matters of national security, and some of the grounds of cancellation, the government has constantly argued that this is a matter of national security or this is a matter of public interest, and then the courts don't interfere. So on that, certainly we, I would say the courts take a very deferential approach to that. But one, there was an Insaf judgment a year ago in which the court has at times did rein in some of the provisions of the FCRA Act. And this is something that we can be hopeful in the future, where the Act is in its ground of cancellation being extremely vague, overbroad. These are some provisions that the court could possibly rein in the government on and maybe read down what you call some of these sections. But like Tehmina said, that big judgment awaited in the Supreme Court where the challenge to some of the amendment provisions will definitely define the scope of the Act, how the Act interplays with fundamental rights under the Constitution. And once that judgment comes out, we'll have a little more clarity on how the high courts will move. So just broadly speaking, procedure, the courts are very strict. On grounds of cancellation, the courts will be a bit more deferential, but that does not mean that the courts will not set aside grounds of cancellation when they're illegal or unfair.
Yeah, thank you, Abhishek, for that. There is one more question, that is it possible to sell assets to pay the debt of the NGO incurred to buy property? Is it possible to sell assets to pay the debt of the NGO incurred to buy property?
When you the normal course, yes, it is. But remember, if you have sold the property, and if there is a debt, normally the debt will not appear in the FCRA account. So debt obviously would be appearing in the local account. So then it would amount to transferring the money to local. That's where you will contravene this. So if you are in the local accounts, you are doing this, there is no problem. But if the asset was purchased with foreign contribution and the repayment involves a loan taken and utilized for FCRA fund, because obviously a loan taken cannot be used for FCRA funds, because FCRA, remember, you are expected to keep an account for FCRA separately. What does that mean? Whatever foreign contribution you have received and what you have utilized out of that on a cash basis, not on a mercantile basis, you are expected to keep. That's what the foreign contribution account is all about, right? So you cannot mix the two. So if it is an FCRA account asset sold, you cannot pay for a local for the debt. That's the answer. But otherwise, yes, you can.
Thank you,
I
sir,
hope
for
I'm
that.
clear.
Yes, yes, sir, absolutely. One question people have, which has been recurring through and through, is that when you do not hear on your application, what are we supposed to do? Is a recurring theme in many of the questions. That is, we have filed our applications, but we have not heard anything. So what are we supposed to do in such a circumstance? So if you could answer that, or if anybody from the panel can answer that question, that will be very helpful.
You have covered it in some way. You would like to answer, I'm sure.
Yeah, we did cover it, right? Yes. So there's nothing you have to do in sense of, going to the department or anything like that. From whatever we heard, hopefully what you've heard from for the whole sessions, you could probably go and revisit the PPTs and see. We talked about sanitizing accounts. We talked about checking your application, and see what you've done. Has there been any violation? So just get ready for inquiries that you might get from them. So the government is at work on your application. Just be assured of that. Yeah.
Yeah.
So on the context of selling assets, Robin, I saw an interesting question. Can I take that?
Please. Yeah.
So there was a question, I can't place it right now, but I read it earlier on. Somebody asked, I have been denied my renewal. So we said that you cannot use foreign contribution nor receive foreign contribution, but you can go ahead and use your assets. So he says, can I sell my assets and use that money? So that was the question. I just would like to answer that. See, we said you can live in your building, but the minute you sell an asset, when you encash it, it becomes foreign contribution again. So the prohibition will apply. So you cannot use that money. So you want to add anything to that?
No, I think that's right. That's a fine distinction. You have answered very well.
Thank you, ma'am. Thank you, sir, for that. There's one question which is basically asking, that is, the application is pending and it is in process. The inquiry has also been completed by the field officers. Unfortunately, 2 of the trustees are moving out of our ministry and request to be relieved of their role in the trust. Will this affect the application process, or should I request them to stay on till we hear from the MHA?
Yeah, it's a very practical question. You know what? If the inquiry is complete, perhaps that may not, unsettle the whole matter right now. If it is feasible, I would suggest during this period, don't allow any changes. And it would be wise on your part to request them to stay on. Inquiry, everything is over. You only have to get. So get that registration in your hand and then make the changes. Otherwise, yes, you made the changes and you did not inform, could be an issue. Please remember, whenever there is a change in the board, you are expected to file and intimate by filing form number 6E on that. Now, though it says intimation, it also says it becomes effective on approval. There's a contradiction, but whenever there is a contradiction, play it safe. That means you need to get the permission. So in view of that, I would suggest don't disturb the apple cart. Leave it like that and request them to stay would be wiser under these circumstances.
I would just add to take heed to that, because the cancellation grounds are becoming so broad that something as small as a non-intimation of change of trustees could be violation of a provision of the Act and can lead to cancellation also. So please take care and follow that.
There is one more practical question. I think maybe, the question is, the organization had applied for renewal in 2016. Some clarification was asked and clarified, but they did not receive the renewal. And they had to pay the penalty, that is compounding. But then they applied again, but now it shows in the website as it seems to be expired. So they're asking what is the recourse at this point. I'll just repeat it once again for the benefit of the panelists. An organization applied for renewal in 2016. A clarification was asked and clarification was given, but they did not receive the renewal. And they also had to pay a penalty, compounding. And then when they applied again, the website seems to be saying that it seems to be expired and they want to know what is the recourse.
See, if you had applied in 2016, now the question is, that means at that time it was expiring. I'm just looking at the dates. 2016, if you applied, that means somewhere around that period, your renewal was expiring. Now, in which case 2021, it is due for renewal, right? So you have done everything, you have done the compounding and everything, then it has not been cancelled. So you should apply for renewal in 2021. If you are not applied for 2021 for the renewal, obviously it has expired. That's what it is. So you have done the compounding, everything, but don't forget that your period is running and the 5 years is getting over. So sometime in 21, the period is over of that. And so now the question is, if that is the case, you need to look into it and see whether you can make a delayed application for renewal is what you can do. So if it says expired, that is what I would think. Maybe we'll have to look at the dates and look into the details a little more to see that. But generally speaking, this is what I would think. It has expired for this reason, in which case, all right, make a fresh application, which I had mentioned in my presentation. Make a fresh application for a delayed 1,000 rupees you have to pay, 5,000 plus 5,000, make an application. All the best to you.
Thank you, sir. There is one more question. I think there is also in the questions, you can sense a sense of anxiety that the date is fixed at 31st March. So some of these questions are practically kind of asking what needs to be done as a matter of preparation. So another question that has come about is, can we make advance payments of staff salaries and rents before 31st March, maybe up to 3 to 4 months in advance? Is that permissible? Is a question.
See, certainly this will be looked upon as you are trying to circumvent the law. We would certainly not advise you to do that. That's why I told you, at this stage, at best, you may like to pay the March matters, even the March salary, perhaps that may be extended to say, yes, you pay the salaries in advance. Any expenses of them up to March, you can pay. Even what expenses up to March, which are likely to come, ask for the bills, you make the payment, clear all the outstanding liabilities, but don't venture into paying the next year expenses. In case it comes to the notice, it would be considered as a devious method of trying to avoid, and that can go against you.
Thank you, sir.
As I said, if you have, if your business, in the normal course of business, there are advances to be paid, you do that. But normal course of advance, you don't pay advance salary for 3 months to the employees. We don't do that. So, you need to look at it case to case, you need to take a decision.
Yeah, thank you, sir, for that. So now we are basically coming to the last leg of the session, which is basically the vote of thanks. But before that, please note that there is a specific link that is being shared in the chat box, wherein you can actually, connect with the experts, and you can also raise your specific queries there, which in case if you have raised here, and we have received almost about 90 questions, and we've tried to see how much ever we can. So there could have been a human error on our part to not have raised your question. That does not in any way indicate that your question is wrong, or that we didn't have any intention, but it is only because of the the challenge with respect to time that we have. So keeping that in mind, please do click on that link in the chat box, and please do enter the details or your questions, and which will basically enable you to get in touch with the experts and you have your answers specifically answered. Now, I would like to thank every panelist for the amount of time that you have given, for the amount of preparation that you have put, and for beautifully conducting this ADF India webinar on FCRA. It was a fantastic experience, honestly, to be part of this program. I think Mr. Raja B Singh's and his energetic presentation was really keeping us really glued to the screen to actually really understand what the specific challenges are, how to go about. Thank you, Manju ma'am, for the wonderful presentation and the specific ways of understanding of where the FCRA registration stand and what are the different avenues that people have and what are the different remedies. And finally, I would like to thank Abhishek and Tehmina for putting together the challenges in terms of what can be done legally, and also trying to help us understand as to what is the step-by-step process that is available for organizations which are specifically facing challenges, and stressing on the fact that we start with representations, and then we escalate it to have appeals, and then you try to go to the court, and also trying to explain to us the boundaries and the limitations of the court system itself, which was really fantastic. So I would like to thank all of the panelists on behalf of ADF India for being here and for making this wonderful webinar happen. And we would also like to thank all of the participants for your patience and for being here. Even now we have around 300 participants who are part of this program, which really shows the importance of this issue at this present day. So we would like to thank everyone who have participated. So God bless you all, and we would like to end the webinar here. And if you have any specific questions, that will be basically rerouted to that particular link we've already shared in the link. And thank you all once again.
Thank you. Good evening.
Thank you.
Thank you very much. Thank you.
Thank you.
Thanks, everybody, and special thanks to ADF for arranging it at a time so important, timely, making it available.